The Honorable Court of Criminal Appeals of Tennessee is now in session.
This is the continuation of the April session of the Court of Criminal Appeals in Middle Tennessee. With me on the panel today is presiding judge John Everett Williams, to my right from Carroll County, and to my left, Judge Camille McMullen from Memphis and Shelby County. I am Kerwood Witt, and I come from Monroe County. Arguments are 20 minutes aside. If the appellant desires to have a portion of that time reserved for rebuttal, the lawyer needs to announce that at the beginning of argument. Call our case, please.
State of Tennessee versus Edward G. Jameson.
Mr. Rader.
Good afternoon, Your Honors. May it please the court. Patrick Rader on behalf of the appellant, Mr. Jameson. With the court's permission, I'd like to reserve 2 minutes for rebuttal.
Yes.
Your Honors, I raised several issues in my principal brief, but I'd like to just discuss the state's concession and the issue of the statute of limitations today, and rely on my brief for the other issues in my brief, unless there are questions about those other issues. When I originally requested oral argument for this case, I viewed it as a chance to argue what I thought was the central issue in the case, which was the state's failure to timely prosecute Mr. Jameson for counts 1, 3, 7, and 10. However, as this court knows, the state has since conceded that the statute of limitations barred prosecution of counts 1, 3, 7, and 10, and that those convictions need to be dismissed. Given the state's concession, I thought I could use this time to answer any questions Your Honors may have about the state's concession or the statute of limitations issue, as well as to urge this court to accept the state's concession. So if Your Honors have any questions related to the statute of limitations issue or the state's concession, I'd be happy to answer any of those.
Where does that computation leave us, Mr. Rader? Where are we with what is left after those dismissals are effectuated?
As far as Mr. Jameson's sentence?
Yes. Well, convictions and sentences.
That would leave Mr. Jameson with convictions for count 2 for incest, and count 4 incest, count 5 and 6, and 12 and 13. And that would leave his sentence reduced by 20 years.
With those counts remaining as sentenced as they are.
Yes, if this court accepts the state's concession, Mr. Jameson's sentence would be 34 years for the remaining counts.
Were those sentences individually, did they tend to be minimum, medium, or maximum sentences?
I believe, Your Honor, I believe they were in the middle of the range.
Mid-range sentences?
Mm-hmm. Yes, Your Honor.
Should the trial judge have the opportunity to revisit that aggregate sentence in view of the dismissals?
No, Your Honor, I don't believe there's a need for a new sentencing hearing. The state didn't request a new sentencing hearing as a condition of its concession. In addition, Mr. Jameson was essentially sentenced for these convictions, which should have never been prosecuted. And so the natural remedy for that would be a dismissal of those sentences as well, not another bite at the apple for the trial court or the state to essentially re-sentence Mr. Jameson to get that back up closer to the original 54 years. I think the most efficient remedy, Your Honor, I think would be to remand the case for entry of for amended judgments, ordering the dismissal of those convictions for those 4 counts and the sentences with those. And if there are no other questions related to the state's concession, I'd like to clarify one other aspect of our argument. We originally asked for a new sentencing hearing ourselves due to Mr. Jameson's issue with his sentencing range, not knowing that the state would concede to the dismissal of counts 1, 3, 7, and 10. And so given the state's concession, we would argue that Mr. Jameson's sentencing range issue is now moot, and we would ask this court to just simply remand for the entry of amended judgment, dismissing those convictions and sentences. And if your honors have no other questions, I'll rely on my brief. Thank you, your honors.
All right, thank you. All right, General Ball, it's in your court.
Good afternoon. May it please the court, Ben Ball on behalf of the state. I'm here today in place of General Finley, who couldn't make it today. And I'd also like to say it's nice to Judge McMullen and Judge Witt. It's been a while since I've seen you. We've been confined to the same judges in the middle, and it's nice to see both of you. Judge Williams, I've seen you recently, but it's also nice to see you. I have very little to argue today, being that we've conceded this issue. I came prepared to talk about sufficiency and sentencing, but given that the defendant hasn't argued those today, I suppose I'll rely on our brief on this. But if there are any questions you'd like to ask about this, I'm more than happy to answer them. I will say that the state didn't take a position on whether there should be a new sentencing hearing in its brief. We would defer to this court on whether that should happen or not. But if there are no questions, we have conceded this issue, and otherwise ask the court to affirm on the remaining judgments.
All right, thank you.
Thank you.
Any rebuttal, Mr. Rager? I don't guess there is.
No, your honor. We would just reiterate that we would ask this court to accept the state's concession and remand for entry of amended judgments, dismissing Mr. Jameson's convictions and the sentences for counts 1, 3, 7, and 10.
All right.
Thank you,
All
your
right,
honor.
thank you. Thank you. Thank you for appearing today and submitting your arguments. That concludes the argument in this case.
This court stands adjourned.